1 2 1 2. 1 2 3 4. Okay, people are coming in. We're ready to start reading soon. Let's have some fun. Let's learn about the government. Anyway, yeah, you'll hear me soon. As I told you, it's quite delayed. Anyway, We're gonna begin reading now. Chapter 1: The Parliament. Part 1: General. First, I think, clause: legislative power. The legislative power of the Commonwealth shall be vested in a federal parliament, which shall consist of the King, a Senate, and a House of Representatives, and which is hereinafter called the Parliament, or the Parliament of the Commonwealth. 2. Clause 2. I think these are clauses. The Governor General. A Governor General appointed by the King shall be His Majesty's representative in the Commonwealth, and shall have and may exercise in the Commonwealth during the Queen's pleasure, but subject to the Constitution. Such powers and functions of King as His Majesty may be pleased to assign to him. The third clause: salary of Governor General. There shall be payable to, look, for anyone listening, this is this constitution book that I have here. It's not completely up to date, and it talks about the Queen instead of the King, but it's going to be a bit too difficult for me to replace every word on demand. So it's going to be a bit outdated, and you'll hear about the Queen. But anyway. There shall be payable to the Queen out of the Consolidated Revenue Fund of the Commonwealth, for the salary of the Governor-General, an annual sum which, until the Parliament otherwise provides, shall be £10,000. The salary of the Governor-General shall not be altered during his continuance in office. 4. Provisions relating to the Governor-General. The provisions of this Constitution relating to the Governor-General extend and apply to the Governor-General for the time being, or such person as the Queen may appoint to administer the government of the Commonwealth, but no such person shall be entitled to receive any salary from the Commonwealth in respect to any other office during his administration of the government of the Commonwealth. 5. Sessions of Parliament, prorogation and dissolution. The Governor-General may appoint such times for holding the sessions of the Parliament as he thinks fit, and may also from time to time, by proclamation or otherwise, prorogue the Parliament, and may in manner dissolve the House of Representatives. Summoning Parliament. After any general election, the Parliament shall be summoned to meet not later than 30 days after the day appointed for the return of the writs. First Session. The Parliament shall be summoned to meet not later than 6 months after the establishment of the Commonwealth. 6. Yearly Session of Parliament. There shall be a session of the Parliament once at least in every year, so that 12 months shall not intervene between the last sitting of the Parliament in one session and its first sitting in the next session. Part 2. The Senate. Number 7. The Senate. The Senate shall be composed of senators for each state, directly chosen by the people of the state, voting, until the Parliament otherwise provides, as one electorate. But until the Parliament of the Commonwealth otherwise provides, the Parliament of the state of Queensland, if that state be an original state, may make laws dividing the state into divisions and determining the number of senators to be chosen for each division, and in the absence of such provision, the state shall be one electorate. Until the Parliament otherwise provides, there shall be 6 senators for each original state. The Parliament may make laws increasing or diminishing the number of senators for each state, but so that equal representation of the original state shall be maintained, and that no original state shall have less than 6 senators. The senators shall be chosen for a term of 6 years, and the names of the senators chosen for each state shall be certified by the Governor by the Governor to the Governor-General. Number 8. Qualification of electors. The qualification of electors of senators shall be in each state which is prescribed by this Constitution or by Parliament. As the qualification for senators of members of the House of Representatives, but in the choosing of senators, each elector shall vote only once. Number 9. Method of election of senators. The Parliament of the Commonwealth may make laws prescribing the method of choosing senators, but so that the method shall be uniform for all the states. Subject to any such law, the Parliament of each state may make laws prescribing the method of choosing the senators for that state. Time and places. The Parliament of a state may make laws for determining the times and places of elections of senators for the state. Number 10. Application of state laws. Until the Parliament otherwise provides, but subject to this Constitution, the laws in force in each state, for the time being relating to the elections for the more numerous houses of Parliament of the state, shall as nearly as practicable apply to elections of senators for the state. Number 11. Failure to choose senators. The Senate may proceed to the dispatch of business, notwithstanding the failure of any state to provide for its representation in the Senate. Number 12. Issue of writs. The governor of any state may cause writs to be issued for elections of senators for the state. In the case of the dissolution of the Senate, the writs shall be issued within 10 days from the proclamation of such dissolution. Number 13. Rotation of senators. As soon as may be after the Senate first meets, and after each first meeting of the Senate following a dissolution thereof, the Senate shall divide the senators chosen for each state into 2 classes, as nearly equal in number as practicable, and the places of the senators of the first class shall become vacant at the expiration of the 3 years, and the places of those of the second class at the expiration of 6 years from the beginning of their term of service. And afterwards the places of senators shall become vacant at the expiration of 6 years from the beginning of their term of service. The election to fill vacant places shall be made within 1 year before the places are to become vacant. For the purposes of this section, the term of service of a senator shall be taken to begin on the first day of July, following the day of his election, except in the cases of the first election and of the election next after any dissolution of the Senate, when it shall be taken to begin on the first day of July preceding the day of his election. Bit of a mouthful. Number 14. Further provision for rotation. Whenever the number of senators for a state is increased or diminished, the Parliament of the Commonwealth may make such provision for the vacating of the places of senators for the state as it deems necessary to maintain regularity to the rotation. Number 15. Casual vacancies. If the place of a senator becomes vacant before the expiration of his term of service, the Houses of Parliament of the state for which he was chosen, sitting and voting together, or, if not, there is only one House of that Parliament, that House shall choose a person to hold the place until the expiration of the term. But if the Parliament of the state is not in session when the vacancy is notified, the governor of the state, with the advance of the Executive Council thereof, may appoint a person to hold the place until the Executive Council thereof may appoint a person to hold until the expiration of 14 days from the beginning of the next session of Parliament of the state, or the expiration of the term, whichever first happens. Where a vacancy has at any time occurred in the place of a senator chosen by the people of a state, and at the time when he was so chosen, he was publicly recognised by a particular political party as being an endorsed candidate of that party and publicly represented himself to be such a candidate, a person chosen or appointed under this section in consequence of that vacancy, or in consequence of that vacancy and a subsequent vacancy or vacancies, shall, unless there is no member of that party available to be chosen or appointed, be a member of that party. Where A. In accordance with that last preceding paragraph, a member of the Parliament, a particular political party is chosen or appointed to hold the place of a senator whose place had become vacant, and B. Before taking his seat he ceases to be a member of that party, otherwise than by reason of the party having ceased to exist. He shall be deemed not to have been chosen or appointed, and the vacancy shall be again notified in accordance with the section 21 of this Constitution. The name of any senator chosen or appointed under this section shall be certified by the Governor of the State to the Governor-General. If the place of a senator chosen by the people of a state at the election of senators last held before the commencement of the Constitution alteration, Senate Casual Vacancies 1977, became vacant before that commences, and, at the commencement, no person chosen by the House or Houses of Parliament of the state, or appointed by the Governor General of the state, just the Governor of the state, in consequence of that vacancy or in consequence of that vacancy, at a subsequent vacancy or vacancies. This thing's a bloody mouthful. Held office. This section applies as if the place of the senator chosen by the people of the state had become vacant after that commencement. A senator holding office at the commencement of the Constitution alteration, Senate Casual Vacancies 1977, being a senator appointed by the governor of a state in consequence of a vacancy that had at any time occurred in the place of a senator chosen by the people of that state, shall be deemed to have been appointed to hold the place until the expiration of 14 days after the beginning of the next session of the Parliament of the state that commenced or commences after he was appointed, and further action under this section shall be taken as if the vacancy in the place of the senator chosen by the people of the state had occurred after that commencement. Subject to the next succeeding paragraph, a senator holding office at the commandment of the Constitution alteration, Senate Casual Vacancies 1977, who is chosen by the House or Houses of Parliament of the state in consequence of a vacancy that had at any time occurred in the place of the senator chosen by the people of the state, shall be deemed to have been chosen to hold office until the expiration of the term of the service of the senator elected by the people of the state. There is no punctuation in this thing, goodness sakes. If at all before the commencement of the Constitution alteration, Senate Casual Vacancies 1977, a law to alter the Constitution entitled Constitution Alteration, Simultaneous Elections 1977 came into operation, a senator holding office at the commencement of that law, who is chosen by the House or Houses of Parliament of the state in consequence of a vacancy that had at any time occurred in the place of a senator chosen by the people of the state, shall be deemed to have been chosen to hold office. A. If the senator elected by the people of the state had the term of service expiring on the 13th day of June, 1978, until the expiration or dissolution of the first House of Representatives to expire or be dissolved after that law came into operation, or B. If the senator elected by the people of the state had a term of service expiring on the 30th day of June, 1981, until the expiration or dissolution of the second House of Representatives to expire or be dissolved after the law came into operation, or if there is an earlier dissolution of the Senate until that dissolution. 16. Qualifications of Senator. The qualifications of a Senator shall be the same of those of a member of the House of Representatives. 17. Election of President. The Senate shall, before proceeding to the dispatch of any other business, choose another senator to be the President of the Senate, and as often as the office of President becomes vacant, the Senate shall again choose a senator to be the President. The President shall cease to hold his office if he ceases to be senator. He may be removed from office by vote of the Senate, or he may resign his office or his seat by writing a jest to the Governor General. 18. Absence of President. Before or during any absence of President, the Senate may choose a senator to perform his duties in his absence. Number 19. Resignation of Senator. A senator may, by writing a jest to the President or the Governor General, if there is no President or if the President is absent from the Commonwealth, resign his place, which thereupon shall become vacant. Number 20. Vacancy by absence. The place of the senator shall become vacant if for 2 consecutive months of any session of Parliament he, without the permission of the Senate, fails to attend the Senate. Number 21. Vacancy to be notified. Whenever a vacancy happens in the Senate, the President, or if there is no President, or if the President is absent from the Commonwealth, the Governor General shall notify the same of the Governor of the state in the representation of which the vacancy has happened. Number 22. Quorum. Until the Parliament otherwise provides, the presence of at least 1/3 of the whole number of the senators shall be necessary to constitute a meeting of the Senate for the exercise of its powers. Number 23. Voting in Senate. Questions arising in the Senate shall be determined by a majority of votes, and each senator shall have 1 vote. The President shall in all cases be entitled to vote, and when the votes are equal, the question shall pass in the negative. Part 3, the House of Representatives. Just going to have a wee drink of water. I can hit in the call. I can. No, it's just me. Anyway, Part 3, the House of Representatives. 24, Constitution of House of Representatives. The House of Representatives shall be composed of members directly chosen by the people of the Commonwealth, and the number of such members shall be, as nearly as practicable, twice the number of the senators. The number of members chosen in the several states shall be bloody heck. The number of members chosen in the several states shall be in proportion to the respective members of their people, and shall, until Parliament otherwise provides, be determined, whether necessary, in the following manner. 1. A quota shall be ascertained by dividing the number of the people of the Commonwealth, as shown by the latest statistics of the Commonwealth, by twice the number of the senators. 2. The number of members to be chosen in each state shall be determined by dividing the number of the people of the state, as shown by the latest statistics of the Commonwealth, by the quota, and, if on such division there is a remainder greater than one half of the quota, one more member shall be chosen by the state. But notwithstanding anything in this section, 5 members at least shall be chosen in each original state. Number 25. Provisions as to races disqualified from voting. Anyway, for the purposes of the last section, if by the law of any state all persons of any race are disqualified from voting at elections for the more numerous House of the Parliament of the state, then in reckoning the number of the people of the state of the Commonwealth, persons of that race resident in that state shall not be counted. Number 26. Representatives in the First Parliament. Notwithstanding anything in Section 24, the number of members to be chosen in each state at the first election shall be as follows. New South Wales, 23. Victoria, 20. Queensland, 8. South Australia, 6. And Tasmania, 5. Provided that if Western Australia is an original state, the numbers shall be as follows. New South Wales, 26. Victoria, 23. Queensland, number 9. South Australia, 7. Western Australia, 5. And Tasmania, also 5. Number 27. Alteration of numbers of members. Subject to this constitution, the Parliament may make laws for increasing or diminishing the number of the members of the House of Representatives. Number 28. Duration of House of Representatives. Every House of Representatives shall continue for 3 years from the first meeting of the House, and no longer but may sooner dissolved by the Governor-General. Number 29. Electoral divisions. Until the Parliament of the Commonwealth otherwise provides, the Parliament of any state may make laws for determining that each divisions of yeah, I just noticed the speech volume, the stream volume's a wee bit quiet. I'm going to try and make myself a bit louder. They will later on. Anyway. (28) Duration of House of Representatives. Every House of Representatives shall continue for 3 years from the first meeting of the House, and no longer but may be sooner dissolved by the Governor-General. Number 29. Electoral divisions. Until the Parliament of the Commonwealth otherwise provides, the Parliament of any state shall make it of any state may make laws for determining the divisions in each state for which members of the House of Representatives may be chosen, and the number of members to be chosen for each division. A division shall not be formed out of the parts of different states. In the absence of other provision, each state shall be one electorate. Number 30. Qualification of electors. Until the Parliament otherwise provides, the qualification of electors of members of the House of Representatives shall be in each state that which is prescribed by the law of the state as the qualification of electors of one more numerous House of Parliament of the state, but in the choosing of members each elector shall only vote once. Number 31. Application of state laws. Can I just say, for anyone who wants to improve their reading skills, reading out loud, this is challenging because it's just full of run-on sentences. There's no, barely any full stops. It's just walls of words. What was I just up to? 30 qualification of electors? I think I read that, yeah. Number 31. Application of state laws. Until the Parliament otherwise provides, but subject to this Constitution, the laws in force in each state for the first time being relating to the elections for the more numerous House of the Parliament of the state shall as nearly be as practicable apply to elections in the state of members of the House of Representatives. Number 32. Writs for general election. The Governor-General and Council may cause writs to be issued for Governor for general elections of members of the House of Representatives. After the first general election, the writs shall be issued within the 10 days of the expiry of the House of Representatives or from the proclamation of a dissolution thereof. Number 33. Writs for vacancies. Whenever a vacancy happens in the House of Representatives, the Speaker shall issue his writ for the election of a new member, or if there is no Speaker, or if he is absent from the Commonwealth, the Governor-General in Council may issue his writ. Yes, anyway. 34. Qualification of members. Until the Parliament otherwise provides, the qualifications of a member of the House of Representatives shall be as follows. 1. He must be of the full age of 21 years and must be an elector entitled to vote at the election of members of the House of Representatives, or a person qualified to become such elector, and must have been for 3 years at the least a resident within the limits of the Commonwealth as exiting at the time when he is chosen. 2. He must be a subject of the Queen, either natural born or for at least 5 years naturalised under a law of the United Kingdom, or of a colony which has become a state, or of the Commonwealth, or of a state. This is not leisure reading material, I'll be honest. It's purely document. Number 35. Election of Speaker. The House of Representatives shall, before proceeding to the dispatch of any other business, choose a member to be the Speaker of the House, and as often as the office of Speaker becomes vacant, the House shall again choose a member to be the Speaker. The Speaker shall cease to hold his office if he ceases to be a member. He may be removed from his office by the vote of a House, or he may resign his office or seat by writing addressed to the Governor-General. Number 36. Absence of a Speaker. Before or during any absence of the Speaker, the House of Representatives may choose a member to perform his duties in his absence. Number 37. Resignation of a member. A member may by writing address to the Speaker or to the Governor-General if there is no Speaker, or if the Speaker is absent from the Commonwealth, resign his place which thereupon shall become vacant. Number 38. Vacancy by absence. The place of a member shall become vacant if for 2 consecutive months of any session of the Parliament he, without the permission of the House, fails to attend the House. Number 39. Quorum. Until the Parliament otherwise provides, the presence of at least 1/3 of the whole member of the members of the House of Representatives shall be necessary to constitute a meeting of the House for the exercise of its powers. Number 40. Voting in House of Representatives. Questions arising in the House of Representatives shall be determined by a majority of votes other than that of the Speaker. The Speaker shall not vote unless the members are equal, and then he shall have a casting vote. Part 4. Both Houses of the Parliament. Number 41. Right of electors of states. No adult person who has or acquires a right to vote at the elections for the more numerous House of the Parliament or state shall, while the right continues, be prevented by any law of the Commonwealth from voting at the elections for either House of Parliament or of the Commonwealth. Number 42. Oath or affirmation of allegiance. Every senator and every member of the House of Representatives shall, before taking his seat, make and subscribe before the Governor-General or some person authorised by him an oath or affirmation of allegiance in the form set forth in schedule to this Constitution. Number 43. Member of one House or a member of one House ineligible for other. A member of either House of the Parliament shall be incapable of being chosen or of sitting as a member of the House. Number 44. Disqualification. Any person who, 1. is under any acknowledgement of allegiance, obedience, or adherence to a foreign power, or is subject or a citizen, or entitled to the rights or privileges of a subject or a citizen or a foreign power, or 2. is attainted of treason, or has been convicted and is under sentence, or subject to be sentenced for any offence punishable under the law of the Commonwealth or of a state by imprisonment for 1 year longer, or 3. is an undischarged bankrupt or insolvent, or 4. holds any office of profit under the Crown, or any pension payable during the pleasure of the Crown out of any of the revenues of the Commonwealth, or 5. has any direct or indirect pecuniary interest in any agreement with the public service of the Commonwealth, otherwise than as a member in the common with other members of an incorporated company consisting of more than 25 persons, shall be incapable of being chosen or of sitting as a senator or a member of the House of Representatives. But subsection 4 does not apply to the House of any of the Queen's Ministers of State of the Commonwealth, or of any of the Queen's Ministers for State, or to receipt of pay, half pay, or pension by any person as an officer by a member of the Queen's Navy or Army, or to the receipt of pay as an officer of member of the naval military forces of the Commonwealth by any person whose service are not wholly employed by the Commonwealth. Number 45. Vacancy on happening of disqualification. If a senator or member of the House of Representatives, 1. becomes subject to any of the disabilities mentioned in the last preceding section, or 2. takes a benefit, whether by assignment, composition, or otherwise, of any law relating to bankrupt or insolvent debtors, or 3. directly or indirectly takes or agrees to take any fee of honorarium for services rendered to the Commonwealth, or of services rendered in the Parliament to any person or state, his place shall thereupon become vacant. Number 46. Penalty for sitting when disqualified. Until the Parliament otherwise provides, any person declared by this Constitution to be incapable of sitting as a senator or as a member of the House of Representatives shall, for every day on which he so sits, be liable to pay the sum of £100 to any person who sues for it in any court of competent jurisdiction. Number 47. Disputed elections. Until the Parliament otherwise provides, any question respecting the qualification of a senator or of a member of the House of Representatives or respecting a vacancy in either House of Parliament, and any question of a disputed election to either House, shall be determined by the House in which the question arises. Number 48. Allowance to members. Until the Parliament otherwise provides, each senator and each member of the House of Representatives shall receive an allowance of £400 a year, to be reckoned from the day on which he takes his seat. Number 49. Privileges, etc. of Houses. The powers, privileges, and immunities of the Senate and the House of Representatives and of the members of the committees of each house shall be such as are declared by the Parliament, and until declared shall be those of the and until declared shall be those of the Commons House of Parliament of the United Kingdom, and of its members and committees at the establishment of the Commonwealth. Number 50. Rules and Orders. Each House of the Parliament may make rules and others with respect to 1. The mode in which its powers, privileges, and immunities may be exercised and upheld. 2. The order and conduct of its businesses and proceedings, either separately or jointly with the other house. Part 5. Powers of the Parliament. 51. Legislative powers of the Parliament. The Parliament shall, subject to this Constitution, have power to make laws for the peace, order, and good government of the Commonwealth with respect to 1. Trade and commerce with other countries and among the states. 2. Taxation, but so as not to discriminate between states or parts of states. 3. Bounties on the production or export of goods, but so that such bounty shall be uniform throughout the Commonwealth. 4. Borrowing money on the public credit of the Commonwealth. 5. Postal, telegraphic, telephonic, and other like services. 6. The naval and military defence of the Commonwealth and of the several states, and the control of the forces to execute and maintain the laws of the Commonwealth. 7. Lighthouses, lightships, beacons, and buoys. 8. Astronomical and meteorological observations. 8. Quarantine. 10. Fisheries in Australian waters beyond territorial limits. 11. Census and statistics. 12. Currency, coinage, and legal tender. 13. Banking other than state banking, also state banking extending beyond the limits of the state concerned, the incorporation of banks, and the issue of paper money. Not even paper anymore. What number is this? 14. Insurance other than state insurance, also state insurance extending beyond the limits of state concerned. 15. Weights and measures. 16. Bills of exchange and promissory notes. 17. Bankruptcy and insolvency. 18. Copyrights, patents of inventions and designs of trademarks. 19. Naturalizations and aliens. 20. Foreign corporations and trading or financial corporations formed within the limits of the Commonwealth. 21. Marriage. 22. Divorce and matrimonial causes and in relation thereto parental rights and the custody and guardianship of infants. 23. Invalid and old age pensions. 23A. The provision of maternity allowances, widows' pensions, child endowment, unemployment, pharmaceutical, sickness and hospital benefits, medical and dental services, but not so as to authorise any form of civil conscription, benefits to students and family allowances. This is 24. The service and execution throughout the Commonwealth of the civil and criminal process and the judgments of the courts of the states. 25. The recognition throughout the Commonwealth of the laws of the public acts and the judicial proceedings of the states. Okay, I'm not even going to bother counting anymore. These Roman numerals. The people of any race for whom it is deemed necessary to make special laws, immigration and emigration, the influx of criminals, external affairs, the relations of the Commonwealth with the islands of the Pacific, the acquisition of property on just terms from any state or person for any purpose in respect of which the Parliament has power to make laws, the control of railways with respect to transport for the naval and military purposes of the Commonwealth, the acquisition with the consent of a state of any railways of the state on terms arranged between the Commonwealth and the state, railway construction and extension of any state with the consent of that state, conciliation and arbitration for the preservation and settlement of industrial disputes extended beyond the limits of any one state, matters in respect of which this constitution makes provision until the Parliament otherwise provides. Matters referred to the Parliament of the Commonwealth by the Parliament of Parliaments. Let's read that again. Matters referred to the Parliament of the Commonwealth by the Parliament of Parliaments of any state or states, but so that the law shall extend only to states by whose parliaments the matter is referred or which afterwards adopt the law. The exercise within the Commonwealth at the request of or with the concurrence of the parliaments of all of the states directly concerned of any power which can at the establishment of this constitution be exercised only by the Parliament of the United Kingdom or by the Federal Council of Australasia. What is this even? Matters incidental to the execution of any power vested by this constitution in the Parliament or in any either house thereof, or in the government or the Commonwealth, or in the federal judicature, whatever that word is, I've never read it before, or in any department or officer of the Commonwealth. Okay, we're at the end of that list. And it is the Roman numeral at the end, XXXIX. I don't know what number that is, but it's no, it's XXXIX. Yeah, probably. This is from copyright 2018, first published January 1995, revised reprint October 2017. That's a really good question, to be honest. We don't use we switch to decimal. We don't use paper, and we use the Australian dollar. The stuff about the Queen, that's understandable, but it is quite outdated. But no. We're actually I'm actually halfway through the entire book. I'll take a break when I get to the end of chapter 1. Yeah. 52. Exclusive powers of the Parliament. The Parliament shall, subject to this Constitution, have exclusive power to make laws for the peace, order, and good government of the Commonwealth with respect to... Oh, there's another list, but don't worry, it's not long. 1. The seat of government of the Commonwealth and all places acquired by the Commonwealth for public purposes. 2. Matters relating to any department of the public service, the control of which is by this Constitution transferred to the executive government of the Commonwealth. 3. Other matters declared by this Constitution to be within the exclusive power of the Parliament. Number 53. Powers of the Houses in respective legislation. Proposal... One moment. Alright, we're nearly at the end of chapter 1. And there's some juicy bits coming up. Royal Assent. Yes, 53. Powers of the Houses in respect of legislation. Proposed laws appropriating revenue or monies, or imposing taxation shall not originate in the Senate, but a proposed law shall not be taken to appropriate revenue or monies, or to impose taxation by reason only of its containing provisions, for the imposition or appropriation of fines, or other pecuniary penalties, or for the demand of payment or appropriation of fees for licenses, or fees for services under the proposed law. The Senate may not amend proposed laws imposing taxation, or proposed laws appropriating revenue or monies of the ordinary annual services of the government. The Senate may not amend any proposed law so as to increase the proposed charge or burden on the people. The Senate may at any stage return to the power of the representatives any proposed law which the Senate may not amend, requesting by message but the omission or amendment of any items by provision therein. And the House of Representatives may, if it thinks fit, make any of such omissions or amendments, with or without modifications. Except as provided in this section, the Senate shall have equal power with the House of Representatives in a report of all proposed laws. Number 54. Appropriation Bills. The proposed law which appropriates revenue or monies for the ordinary annual services of the government shall deal only with such appropriation. 55. Tax Bill. Laws imposing taxation shall deal only with the imposition of taxation, and any provision therein dealing with any other matter shall be of no effect. Laws imposing taxation, except laws imposing duties of customs or of excise, shall deal with one subject of taxation. Only by laws imposing duties of customs shall deal with the duties of customs only, and laws imposing duties of excise shall deal with duties of excise only. I didn't stuff that up. You heard correctly. That was a massive mouthful. I would not recommend reading legal documents for leisure, a bit like I'm doing now. Number 56. Recommendation of money votes. A vote, resolution, or proposed law for the appropriation of revenue or monies shall not be passed unless the purpose of the appropriation has in the same session been recommended by the Governor-General to the House in which the proposal originated. 57. Disagreement between the Houses. If the House of Representatives passes any proposed law, and the Senate rejects or fails to pass it, or passes it with the amendments to which the House of Representatives will not agree, and if after an interval of 3 months and the House of Representatives in the same or the next session again passes the proposed law with or without any amendments which have been made, suggested or agreed to by the Senate, and the Senate rejects or fails to pass it, or passes it with amendments to which the House of Representatives will not agree, the Governor-General may dissolve the Senate and the House of Representatives simultaneously, but such dissolution shall not take place within 6 months. Before the date of the expiry of the House of Representatives by a fraction of time. If after such dissolution of the House of Representatives again passes the proposed law, with or without any amendments which have been made, suggested or agreed to by the Senate, and the Senate rejects or fails to pass it, passes it with amendments to which the House of Representatives will not agree, the Governor-General may convince a joint sitting of the members of the Senate and of the House of Representatives. The members present at the joint sitting may deliberate and shall vote together upon the proposed law, as last proposed by the House of Representatives, and upon amendments, if any which have been made therein by one House and not agreed to by the other, and any such amendments which are affirmed by an absolute majority of the total number of the members of the House of the Senate and the House of Representatives, shall be taken to or have been carried, and if the proposed law with amendments, if any, so carried is affirmed by an absolute majority of the total number of the houses of the members of the Senate and Houses of Representatives, it shall be taken to have been duly passed by both houses of the Parliament, and shall be presented to by the Governor-General for the Queen's assent. 58. Royal assent to bills. When a When a proposed law passed by both houses of the Parliament is presented to the Governor-General for the Queen's assent, he shall declare according to his discretion, but subject to this Constitution, that he assents in the Queen's name, or that he withholds assent, or that he reserves the law for the Queen's pleasure. Recommendations by the Governor-General. The Governor-General may return to the House in which it originated any proposed law so presented to him, and may transmit therewith any amendments which he may recommend, and the House may deal with the recommendation. Number 59. Disallowance by the Queen. The Queen may disallow any law within 1 year from the Governor-General's assent, and such disallowance, on being made known by the Governor-General by speech or message of each of the Houses of the Parliament, or by proclamation, shall annul the law from the day when the disallowance is so made known. Number 60. Signification of Queen's pleasure on bills reserved. A proposed law reserved for the Queen's pleasure shall not have any force unless and until within 2 years from the day on which it is preserved to the Governor-General for the Queen's assent to the Governor-General makes known, by speech or message to each of the Houses of Parliament, or by proclamation, that it has received the Queen's assent. Okay, we've finished Chapter 1. We're now up to Chapter 2, the Executive Government. So I'm going to take a small break. Chapter 2, the Executive Government. So,
this God-given land of ours, Australia, this proud possession, our own piece of earth, that was built by our fathers who pioneered our heritage. Here in Australia, the land of our birth. God bless Australia, God bless Australia, home of the Anzac, the strong and the free. It's a homeland, our own land, to cherish for eternity. God bless Australia, the land of the free. Here in Australia, we treasure love and liberty. Our way of life, all for one, one for all. We're a peace-loving race, but should danger ever threaten us, let the world know we will answer the call. God bless Australia, God bless Australia, home of the Anzac, the strong and the free. It's our homeland, our own land, to cherish for eternity. God bless Australia, the land of the free. God bless Australia, God bless Australia, home of the Anzac, the strong and the free. It's our homeland, our own land, to cherish for eternity. God bless Australia, the land of the free. Here in this God-given land of ours.
Have Britons lost the courage of the glorious days of yore? Have they lost the valiant spirit which their doughty fathers bore? They always travelled forward, shall we go tamely back? Shall we look on while the traitors they destroy our Union Jack? Shall we listen to the treason of sedition-nurtured knaves, and condemn our loyal kindred to the fate of wretched slaves? Our fathers travelled forward, shall we go tamely back? Shall we look on while the traitors they destroy our Union Jack? Shall we be crushed like vermin beneath the Gladstone wheel, that he may live in story as the hero of repeal? Shall we no more go forward, but tamely travel back? Shall we look on while the traitors they destroy our Union Jack? He never shall surrender the glories of our past, but shoulder still to shoulder, protect them to the last. We must and shall go forward, we'll never travel back, and forever, aye forever, we shall hoist our Union Jack. surrender the glories of our past, but shoulder still to shoulder, protect them to the last. We must and shall go forward, we'll never travel back, and forever, aye forever, we shall hoist our Union Jack, and forever, aye forever, we shall hoist our Union Jack. Have Britons lost the courage of the glorious days of yore? Have they lost the valiant spirit which their doughty fathers bore? They always travelled forward, shall we go tamely back? Shall we look on while the traitors they destroy our Union Jack? Shall we listen to the treason of sedition nurtured knaves, and condemn our loyal kindred to the fate of wretched slaves? Our fathers travelled forward, shall we go tamely back? Shall we look on while the traitors they destroy our Union Jack? Shall we be crushed like vermin beneath the Gladstone wheel, that he may live in story as the hero of repeal? Shall we no more go forward but tamely travel back? Shall we look on while the traitors they destroy our Union Jack? He never shall surrender the glories of our past, but shoulder still to shoulder, protect them to the last. We must and shall go forward, we'll never travel back, and forever, aye forever, we shall hoist our Union Jack. Surrender the glories of our past, but shoulder still to shoulder, protect them to the last. We must and shall go forward, we'll never travel back, and forever, aye forever, we shall hoist our Union Jack, and forever, aye forever, we shall hoist our Union Jack. Have Britons lost the courage of the glorious days of yore? Have they lost the valiant spirit which their doughty fathers bore? They always travelled forward, shall we go tamely back? Shall we look on while the trail?
We are now going to return to reading. Isn't that exciting? Just going to get ourselves up to date and ready to continue. Alright. Okay, let's press on. We are past halfway now, because that chapter is massive and there's some shorter ones. Anyway, Chapter 2, the Executive Government. Number 61, Executive Power. The executive power of the Commonwealth is vested in the Queen and is exercisable by the Governor-General as the Queen's representatives, and extends to the execution and maintenance of the Constitution and of the laws of the Commonwealth. 62. Federal Executive Council. There shall be a federal executive council to advise the Governor-General in the government of the Commonwealth, and the members of the council shall be chosen and summoned by the Governor-General and sworn as executive councillors, and shall hold office during his pleasure. Number 63. Provisions referring to the Governor-General. The provisions of this Constitution referring to the Governor-General in Council shall be construed as referring to the Governor-General acting with the advice of the Federal Executive Council. 64. Ministers of State. The Governor-General may appoint officers to administer such departments of the Commonwealth as the Governor-General and Council may establish. Such officers shall hold office during the pleasure of the Governor-General. They shall be members of the Federal Executive Council and shall be the Queen's Ministers of State for the Commonwealth. Ministers to sit in Parliament. After the first general election, no Minister of State shall hold office for a longer period than 3 months, unless he or is becomes a minister of a member of the House of Representatives. Number 65. Number of ministers. Until the Parliament otherwise provides, the Ministers of State shall not exceed 7 in number and shall hold such offices as the Parliament prescribes, or, in the absence of the provision of the Governor-General directs. Number 66. Salaries of ministers. There shall be payable to the Queen out of consolidated revenue fund of the Commonwealth for the salaries of the Ministers of State, an annual sum which, until the Parliament otherwise provides, shall not exceed £12,000 a year. £12,000 a year, shoot. There's been a little bit of inflation since then. Number 67. Appointment of civil servants. Until the Parliament otherwise provides, the appointment of and removal of all the officers of the executive government of the Commonwealth shall be vested in the Governor-General and Council, unless the appointment is delegated by the Governor-General and Council or by a law of the Commonwealth to some other authority. 68. Command of naval and military forces. The Commander-in-Chief of the Naval and Military Forces of the Commonwealth is vested in the Governor-General as the Queen's representatives. Number 69. Transfer to certain departments. On a date or dates to be proclaimed by the Governor-General after the establishment of the Commonwealth, the following departments of the public services in each state shall become transferred to the Commonwealth. Posts, telegraphs, and telephones, naval and military defence, lighthouses, lightships, beacons, and buoys, and quarantine. Yes, but the departments of customs and of excise in each state shall become transferred to the Commonwealth on its establishment. Number 70. Certain powers of governors to vest in the Governor-General. In respect of matters which, under this Constitution, pass to the executive government of the Commonwealth, all powers and functions which, at this establishment of the Commonwealth, are vested in the Governor-General of a colony, or in the Governor-General, or in the Governor of a colony with the advice of his Executive Council, or in any authority of a colony, shall vest in the Governor-General, or in the Governor-General and Council, or in the authority exercising similar powers under the Commonwealth, as the case requires. We're now on to Chapter 3, the Judicature. At least I think that's what that word is. Yes, judicature. Yeah, a few new words. Yes, let's update the chapter thingo. Chapter 3, the Judicature. Chapter 3, the Judicature. Number 71. Judicial powers and courts. The judicial power of the Commonwealth shall be vested in a federal Supreme Court, to be called the High Court of Australia, and in such other federal courts as the Parliament creates, and in such other courts as it invests with federal jurisdiction, the High Court shall consist of a Chief Justice and so many other justices, not less than 2, as the Parliament prescribes. Number 72. Judges' appointment, tenure and remuneration. The Justice of the High Court and of the other courts created by the Parliament. Number 1. I'm going a bit mental. 1. Shall be appointed by the Governor-General in Council. 2. Shall not be removed except by the Governor-General in Council on an address from both houses of the Parliament in the same session, praying for such removal on the ground of proved misbehaviour or incapacity. 3. Shall receive such remuneration as the Parliament may fix, but the remuneration, is that a word? Remuneration, not remuneration. Shall not be diminished during their continuance in office. The appointment. I'm losing my mind. The appointment of a justice of a court created by the Parliament shall be for a term expiring upon his attaining the age that is, at the time of his appointment, the maximum age for justices of that court, and a person shall not be appointed as a justice of such a court as if he has attained the age that is for the time being the maximum age for justices of that court. Subject to this section, the maximum age for justices of any court created by the Parliament is 70 years. The Parliament may make a law fixing an age that is less than 70 years as the maximum age for justices of a court created by the Parliament, and may at any time repeal or amend such a law. But any such appeal or amendment does not affect the term of office or of a justice under an appointment made before the repeal or amendment. A justice of the High Court or of a court created by the Parliament may resign his office by writing under his hand delivered to the Governor-General. Nothing in the provisions added to this section by the Constitution, Alteration, Retirement of Judges 1977, affects the continuance of a person in office as a justice of a court under appointment made before the commencement of these provisions. A reference in this section to the appointment of a justice of a High Court or of a court created by the Parliament shall be read as including a reference to the appointment of a person who holds office as a justice of the High Court or of a court created by the Parliament to hold another office of the same court having a different status or designation. Number 73. The High Court shall have jurisdiction with such exceptions and subject to such regulations as the Parliament prescribes to hear and determine appeals from all judgments, decrees and orders and sentences. 1. Of any justice or justices exercising the original jurisdiction of the High Court. 2. Of any other federal court or court exercising federal jurisdiction or the Supreme Court of any state. Or of any court of any state from which at the establishment of the Commonwealth and the appeal lies to the Queen and Council. 3. Of the Interstate Commission but as to questions of law only, and the judgment of the High Court in all such cases shall be final and conclusive. But no exception or regulation prescribed by the Parliament shall prevent the High Court from hearing, the determining and any appealing from the Supreme Court of a state in any matter in which the establishment of the Commonwealth, an appeal lies from such Supreme Court to the Queen and Council. Until the Parliament otherwise provides, the conditions of and restrictions on appeals to the Queen and Council from the Supreme Courts of the several states shall be applicable to appeals from them to the High Court. Number 74. Appeal to Queen and Council. No appeal shall be permitted to Queen and Council from a decision of the High Court upon any question, howsoever arising to the limits into say of the constitutional powers of the Commonwealth and those of any state or states, or as to the limits into say of the constitutional powers of any two or more states, unless the High Court shall certify that The question is one which ought to be determined by Her Majesty in Council. The High Court may so certify if satisfied that for any special reason the certificate should be granted, and thereupon an appeal shall lie to Her Majesty in Council on the question without further leave. Except as provided in this section, this Constitution shall not impair any right which the Queen may be pleased to exercise by virtue of her royal prerogative, to grant special leave of appeal from the High Court to Her Majesty in Council. The Parliament may make laws limiting the matters in which such leave may be asked, but proposed laws containing any such limitation shall be reserved by the Governor-General for Her Majesty's pleasure. Number 75. Original jurisdiction of High Court. In all matters arising under any treaty. That was number 1. Number 2. Affecting consuls or... I need to look that word up. Consuls, yes, I was correct. Number 3, in which the Commonwealth or a person suing or being sued on behalf of the Commonwealth is a party. 4, between states or between residents of different states or between a state and a resident of another state. What is this? Five, in which a writ of mandamus or prohibition of an injunction is sought against an officer of the Commonwealth. The High Court shall have original jurisdiction. Number 76. Additional original jurisdiction. The Parliament may make laws conferring the original jurisdiction on the High Court in any matter. 1. Arising under this Constitution or involving its interpretation. Arising under any laws made by the Parliament. 3. Of Admiralty and Maritime Jurisdiction. 4. Relating to the same subject matter declaimed under the laws of different states. Number 77. Alright. You may have noticed the clauses go from each chapter, they don't reset. We're at 77. The final one, I believe, is 128. Let's keep going. Keep going as far as we can before my head falls off. Number 77, power to define jurisdiction. With respect to any of the matters mentioned in the last 2 sections of the Parliament may make laws. 1. Define the jurisdiction of any federal court other than the High Court. 2. Define the extent to which the jurisdiction of any federal court shall be exclusive of that which belongs to or is invested in the courts of the states. 3. Investing any court of a state with federal jurisdiction. Number 78. Proceedings against Commonwealth or state. The Parliament may make laws conferring rights to proceed against the Commonwealth or a state in respect of matters within the limits of the judicial power. Number 79. Number of judges. The federal jurisdiction of any court may be exercised by such number of the judges of the Parliament prescribes. Number 80. Trial by jury. The trial on indictment of any offence against any law of the Commonwealth shall be by jury, and every such trial shall be held in the state where the offence was committed, and if the offence was not committed within any state, the trial shall be held at such a place or places as the Parliament prescribes. We are now up to Chapter 4, Finance and Trade. And with that, I'm going to go on a short break. One shorter than the previous one.
this proud possession, our own piece of earth, that was built by our fathers who pioneered our heritage. Here in Australia, the land of our birth. God bless Australia, God bless Australia, home of the Anzac, the strong and the free. It's our homeland, our own land, to cherish for eternity. God bless Australia, the land of the free. Here in Australia, we treasure love and liberty. Our way of life, all for one, one for all. We're a peace-loving race, but should danger ever threaten us, let the world know we will answer the call. God bless Australia, God bless Australia, home of the Anzac, the strong and the free. It's our homeland, our own land, to cherish for eternity. God bless Australia, the land of the free. God bless Australia, Australia, home of the Anzac, the strong and the free. It's our homeland, our own land, to cherish for eternity. God bless Australia, the land of the free. Here in this God-given land of ours, Australia, this proud possession.
Have Britons lost the courage of the glorious days of yore? Have they lost the valiant spirit which their doughty fathers bore? They always travelled forward, shall we go tamely back? Shall we look on while the traitors they destroy our Union Jack? Shall we listen to the treason of sedition-nurtured knaves, and condemn our loyal kindred to the fate of wretched slaves? Our fathers travelled forward, shall we go tamely back? Shall we look on while the traitors they destroy our Union Jack? Shall we be crushed like vermin beneath the Gladstone wheel, that he may live in story as the hero of repeal? Shall we no more go forward, but tamely travel back? Shall we look on while the traitors they destroy our Union Jack? He never shall surrender the glories of our past, but shoulder still to shoulder, protect them to the last. We must and shall go forward, we'll never travel back, and forever, aye forever, we shall hoist our Union Jack. surrender the glories of our past, but shoulder still to shoulder, protect them to the last. We must and shall go forward, we'll never travel back, and forever, aye forever, we shall hoist our Union Jack. And forever, aye forever, we shall hoist our Union Jack. Have Britons lost the courage of the glorious days of yore? Have they lost the valiant spirit which their doughty fathers bore? They always travelled forward, shall we go tamely back? Shall we look on while the traitors they destroy our Union Jack? Shall we listen to the treason of sedition-nurtured knaves, and condemn our loyal kindred to the fate of wretched slaves? Our fathers travelled forward, shall we go tamely back? Shall we look on while the traitors they destroy our Union Jack? Shall we be crushed like vermin beneath the Gladstone wheel, that he may live in story as the hero of repeal? Shall we no more go forward, but tamely travel back? Shall we look on while the traitors they destroy our Union Jack? He never shall surrender the glories of our past, but shoulder still to shoulder, protect them to the last. We must and shall go forward, we'll never travel back, and forever, aye forever, we shall hoist our Union Jack.
one moment, let's turn off that fan that you can probably hear. Let's settle down. And return to some reading shortly. Well. Finance and trade. What does the government have? What does the Constitution have to say about this? Let's find out. Okay, we'll resume now. Not too much left. Well, I can't count. So 40 something clauses left. So not too bad. Anyway, Chapter 4, Finance and Trade. 81. Consolidated Revenue Fund. All revenues or monies... All revenues or monies raised or received by the executive government of the Commonwealth shall form one consolidated revenue fund to be appropriated for the purposes of the Commonwealth in the manner and subject to the charges and liabilities imposed by this Constitution. Number 82. Expenditure charged thereon. The coats, charges, and expenses incident to the collection, management, and receipt of the Consolidated Revenue Fund shall form the first charge thereon, and the revenue of the Commonwealth shall be in the first instance be applied to the payment of the expenditure by the Commonwealth. Number 83. Money to be appropriated by law. No money shall be drawn from the treasury of the Commonwealth except under appropriation made by law. But until the expiration of 1 month after the first meeting of the Parliament, the Governor-General in Council may draw from the Treasury and expend such monies as may be necessary for the maintenance of any department transferred to the Commonwealth and for the holding of their first elections for the Parliament. Number 84. Transfer of officers. When any department of the public service public service of the state becomes transferred to the Commonwealth, all officers of the department shall become subject to the control of the executive government of the Commonwealth. Any such officer who is not retained in the service of the Commonwealth shall, unless he is appointed to some other office of equal emolument in the public service of the state, be entitled to receive from the state in any pension, gratuity, or other compensation payable under the law of the state on the abolition of his office. Any such officer who is retained in the service of the Commonwealth shall preserve all his existing and accruing rights, and shall be entitled to retire from office at the time, and on pension or retiring allowance, which should be permitted by the law of the state, if his service with the Commonwealth were a continuation of his service with the state. Such pension or retiring allowance shall be paid to him by the Commonwealth, but the state shall pay to the Commonwealth a part thereof, to be calculated on the proportion which his term of service with the state bears of his whole term of service, and of the service, and for the purpose of the calculation of his salary shall be taken to that paid to him by the state at the time of the transfer. Any officer who is at the establishment of the Commonwealth in the public service of the state, and who is by consent of the governor of the state, with the advice of the executive council thereof, transferred to the public service of the Commonwealth, shall have the same rights as if he had been an officer of a department transferred to the Commonwealth, and are retained in the service of the Commonwealth. Number 85. Transfer of property of state. When any department of public service of a state is transferred to the Commonwealth, 1. All property of the state of any kind used exclusively in the connection. This word is connection with an X. I don't know how I'm supposed to say that. With the department shall become vested in the Commonwealth, but in the case of the departments controlling customs and excise and bounties, for such time only as the Governor-General and Council may declare to be necessary. Number 2. The Commonwealth may require any property of the state of any kind used, but not exclusively used in connection with the department of the value thereof, shall, if no agreement can be made, be ascertained in nearly as it may be the manner in which the value of land or of an interest in land taken by the state for public purposes is ascertained under the law of the state in force at the establishment of the Commonwealth. 3. The Commonwealth shall compensate for the state value of any property passing for the Commonwealth under this section, If no agreement can be made as to the mode of compensation, it shall be determined under the laws made to by the Parliament. 4. The Commonwealth shall, at the date of the transfer, assume the current obligations of the state in respect of the department transferred. Number 86. Customs, excise, and bounties. I don't know why, but these are in angled brackets. Yes. 86. On the establishment of the Commonwealth, the collection and control of duties of customs and of excise, and the control of the payment of bounties shall pass the executive government of the Commonwealth. Number 87. Revenue from customs and excise duties. During a period of 10 years after the establishment of the Commonwealth and thereafter until the Parliament otherwise provides, of the net revenue of the Commonwealth from duties of customs and of excise, not more than 1/4 shall be applied annually by the Commonwealth towards its expenditure. The balance shall, in accordance with this Constitution, be paid to several states or applied towards the payment of interest on debts of the several states taken over by the Commonwealth. Number 88. Uniform duties of customs. Uniform duties of customs shall be imposed within 2 years after the establishment of the Commonwealth. Number 89. Payment to the states before uniform duties. Until the imposition of uniform duties of customs, yes. 1. The Commonwealth shall credit to each state the revenue collected therein by the Commonwealth. 2. The Commonwealth shall debit to each state, and that's 2A. The expenditure therein of the Commonwealth incurred solely for the maintenance or continuance as at the time of transfer of any department transferred to the state of the Commonwealth. 2B. The proportion of the state according to the number of its people in the other expenditure of the Commonwealth. 3. The Commonwealth shall pay to each state month by month the balance, if any, in favour of the state. Number 90. Exclusive power over customs, excise, and bounties. On the imposition of uniform duties of customs, the power of the Parliament to impose duties of customs and of excise, and to grant bounties on the production or export of goods, shall become exclusive. On the imposition of uniform duties of customs in all laws of the several states imposing duties of customs or of excise, or offering bounties on the production or export of goods, shall cease to have effect by grant of any or agreement or any such bounty lawfully made by or under the authority of the government of any state shall be taken to be good if made before the 30th day of June, 1898, and not otherwise. Number 91. Exceptions as to bounties. Nothing in this Constitution prohibits a state from granting any aid or bounty or mining for gold, silver, or other metals, not from granting with the consent of both houses. Of the Parliament of the Commonwealth, pressured by resolution, or any aid or to bounty on the production or export of any goods. Number 92. Trade within the Commonwealth to be free. Just gonna have a drink. My head might fall off soon. Okay, what were we on? I can barely talk anymore, as you can hear, unless I force it. Is this what it's like to lose your voice? Let's find out. Number 92. Trade within the Commonwealth to be free. On the imposition of uniform duties of customs, trade, commerce, and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. But notwithstanding anything in this Constitution, goods imported before the imposition of uniform duties of customs into any state or any colony which whilst the goods remain therein becomes a state, shall on thence passing into another state within 2 years after the imposition of such duties be liable to any duty chargeable on the imposition of such goods into the Commonwealth, less any duty paid in respect of the goods on their importation. Number 93. Payment to states for 5 years after uniform tariffs. During the first 5 years after the imposition of uniform duties of customs, and thereafter until the Parliament otherwise provides: 1. The duties of customs chargeable on goods imported into a state and afterwards passing into another state for consumption, and the duties of excise paid on goods produced or manufactured in a state and afterwards passing into another state for consumption, shall be taken to have been collected not in the former but in the latter state. 2. Subject to the last subsection, the Commonwealth... Oh, they're sections, not clauses. Forgive me, for I am not a legal expert. Number 2. Subject to the last subsection, the Commonwealth shall credit revenue, debit expenditure, and pay balances to several states as prescribed for the period preceding the imposition of uniform duties of customs. Number 94. Distribution of surplus. After 5 years from the imposition of uniform duties of the customs, the Parliament may provide on such basis as it deems fair for the monthly payment of the several states of all surplus revenue of the Commonwealth. Number 95. Custom duties of Western Australia. Ooh, look who's special. Friggin' WA. What happens in WA? Nothing. Why do they get their own section? Anyway. Number 95. Custom duties of Western Australia. Notwithstanding anything in this Constitution, the Parliament of the State of Western Australia, if that state be an original state made during the first 5 years after the imposition of uniform duties of customs, impose duties of customs on goods passing into that state and not originally imported from beyond the limits of the Commonwealth, and such duties shall be collected by the Commonwealth. Oh, I want to die. But any duty so imposed on any goods shall not exceed during the first of such years the duty chargeable on the goods under the law of Western Australia in force at the imposition of uniform duties, and shall not exceed during the second, third, fourth, and fifth of such years respectively 4/5, 3/5, 2/5, and 1/5 of such latter duty. And all duties imposed under this section shall cease at the expiration of the 5th year after the imposition of uniform duties. If at any time during the 5 years the duty on any goods under this section is higher than the duty imposed by the Commonwealth on the importation of the like goods, then such higher duty shall be collected on the goods when imported into Western Australia from beyond the limits of the Commonwealth. Number 96. Financial assistance to states. During a period of 10 years after the establishment of the Commonwealth, and thereafter until the Parliament as provides, the Parliament may grant financial assistance to any state on such terms and conditions as the Parliament thinks fit. Number 97. Audit. Until the Parliament otherwise provides, the laws enforced in any colony which has become or becomes a state with any respect to the receipt of revenue and the expenditure of money on account of the Governor General of the colony, on account of the government of the colony, and the review and order of such receipt and expenditure shall apply to the receipt of revenue and the expenditure of money on account of the Commonwealth in the state in the same manner as if the Commonwealth or the government or an officer of the Commonwealth were mentioned whenever the colony or the government or an officer of the colony is mentioned. Number 98. Trade and commerce includes navigation and state railways. The power of the Parliament to make laws with respect to trade and commerce extends navigation and shipping and to railway to the property of any state. Number 99. Commonwealth not to give preference. The Commonwealth shall not, by any law or regulation of trade, commerce, or revenue, give preference to one state or any part thereof, over another state or any part thereof. I did read that correctly. This is, like I said, this is not for leisure reading. Section 100. I think that means there's only 28 left. 28 sections. Yeah, not much left. Yay, yippee, whoop-de-doo. I love this book. This is my favourite book ever. I love it. Yes, I love this book. It's fun. I'm enjoying this. It's fun. What number were we on? Oh, I didn't even notice Jimmy Savile has just joined the stream. Welcome, Jimmy Savile. I'm so sorry. I don't know how long you joined. I don't know how long ago you joined. But welcome, Jimmy Savile, to the stream and the reading. What section was I just up to? If anyone remembers. For those listening on YouTube, Jimmy Savile is listening with us. Yes, all of it's about customs. I mean the number. Does anyone remember what number I was up to? Oh wait. Oh yeah, I was at 100. Yes, sorry, my apologies. So, someone should have told me Jimmy Savile had joined us. When did Jimmy Savile join the stream? No, nobody knows when Jimmy Savile joined the stream. We'll continue now. "100. Nor abridge right to use water. The Commonwealth shall not, by any law or regulation of trade or commerce, abridge the right of a state or of the residents therein, the reasonable use of the waters or rivers in conservation or irrigation." Jimmy Savile's going. Wait, what? Jimmy Savile just found out why his name is Jimmy Savile. Found out about this Savile by... Come on! Jimmy Savile, come back. I'm sorry, we shouldn't be interrupting this with humour. Oh, he's gone. Jimmy Savile's gone. I'm sorry, guys. But anyway, yeah, that was citizen stuff. So that's probably the only bit worth remembering. Anyway. 101. Interstate Commission. There shall be an interstate commission with any such powers of adjudication and administration as the Parliament deems necessary for the execution and maintenance within the Commonwealth of the provisions of this Constitution relating to trade and commerce and of all laws made thereunder. 102. Parliament may forbid preferences by state. The Parliament may by any law with respect to trade or commerce forbid as to railways any preference or discrimination by any state or by authority constituted under a state if such preference or discrimination is undue and unreasonable or unjust to any state, due regard being had to financial responsibilities incurred by any state in connection with the construction and maintenance of its railways, but no reference or discrimination shall. This is so entertaining. Shall within the meaning of this section be taken to undue and unreasonable or unjust to any state unless so adjudged by the Interstate Commission. What's that? Sorry. 103. Commissioners' appointment, tenure, and remuneration. I've never heard that word before. The members of the Interstate Commission, 1. Shall be appointed by the Governor-General and Council. 2. Shall hold office for 7 years but may be removed within that time by the Governor-General and Council on address from both houses of the Parliament in the same session praying for such removal on the ground of proved misbehaviour or incapacity. 3. Shall receive such remuneration as the Parliament may fix, but such remuneration shall not be diminished from during their continuance in office. 104. Saving of certain rates. Nothing in this constitution shall render unlawful any rate for the carriage of goods upon a railway, the property of a state, if the state is deemed by the Interstate Commission to be necessary for the deployment of the territory of the state, and if the race applies equally to goods within the state and to goods passing into the state from other states. That's real. That's real. I wasn't shipping up there. This is good literature for your leisure, for your enjoyment, and for your education. 105. Taking over public debts of states. The Parliament may take over from the states their public debts or a proportion thereof, including to the prospective numbers of their people as shown by the latest statistics of the Commonwealth, and may convert, renew, or consolidate such debts or any part thereof, and the state shall indemnify the Commonwealth in respect to the debts taken over, and thereafter interest payable in respect of debts shall be deducted and retained from the proportions of the surplus revenue of the Commonwealth payable to the several states, or if such surplus is insufficient, or if there is no surplus, then the deficiency of the whole amount shall be paid by the several states. 105A. We never had a lettered. Jimmy Savile doesn't want to be Jimmy Savile anymore. That's sad. Okay. No, it's child sex assault is not a joke. Don't be a pedophile. I'm sure it says it somewhere in this constitution. We just haven't got there yet. Don't do pedophilia. Anyway, welcome back. No longer Jimmy Savile. Welcome battery assault to this reading. Yeah, as I was saying earlier, child sexual assault is not good. It's bad. You shouldn't do it, and don't do pedophilia. You shouldn't do it. It probably says somewhere in this constitution, because we're not a Middle Eastern Muslim country where pedophilia is practiced. So yeah, let's continue. We're on 105A. We haven't had numbering like that before. Whoa! 105A. Agreements with respect to state debts. 1. Oh, this is going to be a biggie. But we're almost at the end of the finance rubbish. This is, I think, the worst chapter so far. At the end, we might take a break because my computer wants to cool itself down, I can see. I think. Yes. 105A. Agreements with respect to state debts. 1. The Commonwealth may make agreements with the states with respect to the public debts of the states, including A. The taking over of such debts by the Commonwealth. B. The management of such debts. C. The payment of interest in the provision and management of sinking funds in respect of such debts. D. The consolidation, renewal, conservation, conversion and redemption of such debts. E. The indemnification of the Commonwealth by states in respect to debts taken over by the Commonwealth. And F. Borrowing of money by the states or by the Commonwealth or by the Commonwealth for states. This is good literature. 2. The Parliament may make laws for validating any such agreement made before the commencement of this section. 3. The Parliament may take laws for carrying out by the parties thereto of any such agreement. 4. Any such agreement may be varied or rescinded are by the parties thereto. Every such agreement and any such variation thereof shall be binding upon the Commonwealth and the States, parties thereto, notwithstanding anything contained in this Constitution or the Constitution of the several States, or in any law of the Parliament of the Commonwealth or of any State. 6. The powers conferred in this section shall not be construed as being limited in any way by the provisions of Section 105 of this Constitution. That leaves us up to Chapter 5, the States. And we're going to take a short break, as we do at the end of each chapter. Okay, we'll resume shortly.
Australia, this proud possession, our own piece of earth, that was built by our fathers who pioneered our heritage. Here in Australia, the land of our birth. God bless Australia, God bless Australia, all of the Anzac, the strong and the free. It's a homeland, our own land, to cherish for eternity. God bless Australia, the land of the free. Here in Australia, we treasure love and liberty. Our way of life, all for one, one for all. We're a peace-loving race, but should danger ever threaten us, let the world know we will answer the call. God bless Australia, God bless Australia, home of the Anzac, the strong and the free. It's our homeland, our own land, to cherish for eternity. God bless Australia, the land of the free. God bless Australia, Australia, home of the Anzac, the strong and the free. It's our homeland, our own land, to cherish for eternity. God bless Australia, the land of the free. Here in this God-given land of ours, Australia, this proud possession, our own piece of earth, that was built by our fathers who pioneered our heritage. Here in Australia, the land of our birth.
Okay, we're back. We've been streaming for a little over 2 hours, 2 hours and 12 minutes now. We're going to continue reading the Constitution. And we just like to remind everyone listening, that we are against paedophilia in all ways, in all ways, in any capacity. It shouldn't be practiced in whatsoever, in any capacity, mentally, physically. We don't like pedophilia in any way. Anyway, chapter 5, the states. Let's get reading. 106. Saving of constitutions. The constitution of each state of the Commonwealth shall, subject to this constitution, continue as at the establishment of the Commonwealth, or as at the admission or establishment of the state, as the case may be, until altered in accordance with the constitution of the state. I want to... Hang on a second. I just need to charge my phone. Constitution! 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 Freaking love the Constitution. What number were we on? I don't remember. I think we were on 107 saving power of state parliaments. Every power of the parliament of a colony which has become or becomes a state shall, unless it is by this constitution exclusively vested in the parliament of the Commonwealth, or withdrawn from the parliament of the state, continue as at the assumption of the Commonwealth, or as the admission or establishment of the state, as the case may be. 108. Saving of state laws. Every law in force in a colony. Every law enforced in a colony which has become or becomes a state, relating to any matter within the powers of Parliament of the Commonwealth, shall subject to this Constitution, continue in force in the state, and until the provision is made in that behalf by the Parliament of the Commonwealth, the Parliament of the state shall have such powers of alteration and of appeal in respect of any such law as the Parliament of the colony had until the colony became a state. 109. Inconsistency of laws. When a law of a state is inconsistent with a law of the Commonwealth, the latter shall prevail, and the former shall, to the extent of the inconsistency, be invalid. 110. Provisions referring to the governor. The provisions of this constitution relating to the governor of the state extend and apply to the governor for the time being of the state, or other chief executive officer or administrator of the government of the state. 111. States may surrender territory. To who? The Parliament of the state may surrender any part of the state to the Commonwealth, and upon such surrender and the acceptance thereof by the Commonwealth, such part of the state shall become subject to the exclusive jurisdiction of the Commonwealth. 112. States may levy charges for inspection laws. After uniform duties of customs have been imposed, a state may levy on imports or exports, or on goods passing into or out of the state. Such charges may be necessary for executing the inspection laws of the state, but the net produce of all charges levied shall be penis. No, sorry, I'm sorry for saying that word. I apologise. I'm sorry. I'm terribly sorry for saying that word. Produce of all charges so levied shall be for the use of the Commonwealth, and any such inspection laws may be annulled by the Parliament of the Commonwealth. 113. Intoxicating liquids. We don't like those. All fermented, distilled, or other intoxicating liquids passing into any state or remaining therein for use, consumption, sale, or storage shall be subject to the laws of the state as if such liquids had been produced in the state. 114. States may not raise forces, taxation of property of Commonwealth or state. A state shall not, without the consent of the Parliament of the Commonwealth, raise or maintain any naval or military force, or impose any tax on property of any kind belonging to the Commonwealth, nor the Commonwealth impose any tax on property of any kind belonging to a state. 115. States not to coin money. Any state shall not coin money, not making anything but gold and silver coin a legal tender in payment of debts. 116. Commonwealth not to legislate in respect of religion. The Commonwealth shall not make any law for establishing any religion, or for imposing any religious observance, or for prohibiting the free exercise of any religion, and no religious test shall be required as a qualification for any office or public trust under the Commonwealth. Yes. 117. Rights of residence in the states. In the states, not the states. A subject of the Queen, resident in any state, shall not be subject in any other state to any disability or discrimination which would not be equally applicable to him if he were a subject of the Queen resident in such other state. 118. Recognition of laws, etc. of states. Full faith and credit shall be given throughout the Commonwealth. Oh, by the way, we've only got 10 more clauses. Sorry, not clauses. Sections. Only 10 more sections of this Constitution. Full faith and credit shall be given throughout the Commonwealth to the laws, the public acts and records, and to the judicial proceedings of every state. 119. Protection of states from invasion and violence. The Commonwealth shall protect every state against invasion and on the application of the executive government of the state against domestic violence. 120. Custody of offenders against laws of the Commonwealth. Every state shall make provision for the detention in its prisons of persons accused or convicted of offences against the laws of the Commonwealth, and for the punishment of persons convicted of such offences, and the Parliament of the Commonwealth may make laws to give effect to this provision. Okay, we're on to Chapter 6, New States. We're not going to take a break this time since there's not much left. I'm just going to update the chapter marker. Chapter 6, New States. Do I have any water left? I do have a little bit of water left. I'm going to drink that water. Whoa. Mental, chicken oriental. Going for 2 hours and 20 minutes. Anyway, Chapter 5, New States. Is this 5? I don't even bloody know anymore. Yeah, it's Chapter 6, sorry. I'm a bit slow. But we don't have much left. New States. 121. New states may be admitted or established. The Parliament may admit to the Commonwealth or establish new states, and may, upon such admission or establishment, may make or impose such terms and conditions, including the extent of representation in either House of the Parliament, as it thinks fit. 122. Government of territories. The Parliament may make laws for the government of any territory surrendered by any state and accepted by the Commonwealth, of any territory placed by the Queen under the authority of and accepted by the Commonwealth, or otherwise acquired by the Commonwealth, and may allow the representation of such territory in either House of the Parliament to the extent and on the terms which it thinks fit. (123) Alteration of limits of states. The Parliament of the Commonwealth may, with the consent of the Parliament of the State and the approval of the majority of the elected of the State voting upon the election, increase, diminish, or otherwise alter the limits of the State upon such terms and conditions as may be agreed on, and may, with the like consent, make provision respecting the effect of and operation of any increase and diminution of alteration of territory in relation to any state affected. 124. Formation of new states. A new state may be formed by a separation of territory from a state, but only with the consent of the Parliament thereof, and a new state may be formed by the union of two or more states or parts of states, but only with the consent of the Parliament of the states affected. Chapter 7! Chapter 7! I sound like Bruno Parosnik. Chapter 7, Miscellaneous. 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 Normally I would remember how to spell the word miscellaneous, but because my brain and my head is about to fall off, I had to check the book. It reminded me of the spelling a little bit of the anus frog. If any of you are familiar with the anus frog. Yeah, it reminded me of that. Anyway, Chapter 7 Miscellaneous. 125. Seats of Government. The seat of government of the Commonwealth shall be determined by the Parliament, and shall be within territory which shall have been granted to or acquired by the Commonwealth, shall be vested in and belong to the Commonwealth, and shall be in the state of New South Wales, and be distant not less than 100 miles from Sydney. Such territory shall contain an area of not less than 100 square miles, and such portion thereof shall consist of Crown lands, shall be granted to the Commonwealth without any payment therefor. The Parliament shall sit at Melbourne until it meet at the seat of Parliament. No, the Parliament shall sit at Melbourne until it meet at the seat of government. (126) Power to Her Majesty to authorise Governor-General to appoint deputies. The Queen may authorise... yes. I sound like a microwave. The Queen may authorise the Governor-General to appoint any person or any persons, jointly or severally, to be his deputy or deputies within any part of the Commonwealth, and in that capacity to exercise during the pleasure of the Governor-General such powers and functions to the Deputy Governor-General as he thinks fit to assign to such deputy or deputies subject to... Sorry, I'm having a bit of a stroke. Within any part of the Commonwealth, and in that capacity to exercise during the pleasure of the Governor-General to such powers and functions of the Governor-General as he thinks fit to assign to such deputy or deputies subject to any limitations expressed or directions given by the Queen. But the appointment of such a deputy or deputies shall not affect the exercise by the Governor-General himself or any power or function. Well, that was a short chapter, because we are now on to Chapter 8, Alteration of the Constitution. I don't know why I sneezed. That was very inappropriate of me. Chapter 8, Alteration of the Constitution. 128. Mode of altering the Constitution. This Constitution shall not be altered except in the following manner. The proposed law for the alteration thereof must be passed by an absolute majority of each House of the Parliament, and not less than 2 nor more than 6 months after its passage through both houses. The proposed law shall be submitted in each state and territory to the electors qualified to vote in the election of members for the House of Representatives. But if either house passes any such proposed law by an absolute majority, and the other house rejects or fails to pass it, or passes it with any amendments to which the first mentioned house will not agree, and if after an interval of 3 months the first mentioned house in the same or the next session again passes the proposed law by an absolute majority with or without any amendment. Let's see what's on the next page. Oh! This is a fat one, but we're on the home stretch. It's just one big one. Let's prepare. My computer's in a little bit of heat, actually. It's ramping up its fan. The main GPU is running at 77 degrees because it has to encode this stream, I guess. With or without any amendment which has been made or agreed to by the House, by the other House, and such other House rejects or fails to pass it, or passes it with any amendment to which the first mentioned House will not agree, the Governor General may submit the proposed law as the last proposed by... what's this? I'm sorry, I just saw something stupid on the internet. Mental, chicken oriental. Where was I up to? The Governor General may submit the proposed law as last proposed by the first mentioned House, and either with or without any amendment subsequently agreed to by both Houses to the electors in each state, blah blah blah. Read that one. When a proposed law is submitted to the electors, the vote shall be taken in such manner as the Parliament prescribes, but until the qualification of electors of members of the House of Representatives becomes uniform throughout the Commonwealth, only one half of the electors voting for and against the proposed law shall be counted in any state in which adult suffrage prevails. And if in a majority of the states, a majority of the electors voting approve the proposed law, and if a majority of all the electors voting also approve the proposed law, it shall be presented to the Governor General for the Queen's assent. No alteration diminishing the proportionate representation of any state in either House of the Parliament, or the minimum number of representatives in of House of Parliament, the minimum number of representatives in the state of the House of Representatives, or increasing, diminishing, or otherwise altering the limits of the state, or in any member affecting the provisions of the Constitution relating thereto, shall become law unless a majority of electors voting in that state approve the proposed law. In this section, territory means any territory referred to in section 122 of this Constitution, as territory there is in force in the law allowing to representation in the House of Representatives. Now we are on to the schedule. We finished the actual Constitution, now we're on to the schedule, which is actually an exciting bit. The schedule. As I was reading so quickly because I couldn't just wait to read the schedule because it's so much fun. Okay, schedule. Oath. It's a little bit outdated, as we'll soon see. Schedule. Oath. I, my name, do swear that I will be faithful and bear true allegiance to Her Majesty Queen Victoria, her heirs and successors according to law. So help me God! Affirmation. I, my name, do solemnly and sincerely affirm and declare that I will be faithful and bear true allegiance to Her Majesty Queen Victoria, her heirs and successors according to law. So what I just read was the affirmation. The thing before it was the oath. It says, note, the name of the King or Queen of the United Kingdom of Great Britain and Ireland for the time being is to be substituted from time to time. And that's it. We're done. We finished. We could have read the foreword at the beginning and the overview, but it's not actually a part of the Constitution. But we're done. We finished. I've read the Constitution twice. We've finished it. It's done. Thank you so much, Battery Assault. I appreciate your kind words. We're done. I finished reading the Constitution. I've read it twice now. I can't hear what you're saying because of these headphones. They turn themselves off, but I can probably hear you shortly if you keep talking. I've read the Constitution twice now, and I do not understand a single thing. I barely understand a single thing about how this country works. I've read the Constitution twice. And I'm going to go and off myself now. Those on YouTube, someone is watching. Thanks so much. There's somebody else. Thanks so much. No, there's 2 concurrent viewers. And 7 other people have looked onto the stream. Thank you so much, everyone. This will obviously, of course, be on DVR on the YouTube channel. I'm Interested in Apathy. It's been 2 hours and 33 minutes. Thank you so much for watching, everyone. Goodbye.